Hi, Assalamualaikum and good day everyone. Today, me and my fellow friends want to present and solve about the partnership scenario. So, without further ado, let's start.
What is partnership? Alright, according to Section 3, Clause 1 of the Partnership Act, partnership is the relation which subsists between parties carrying on business in common with a view of profit.
Alright guys, so we move on to the question 2A, which is method of dissolutions. Under dissolution by a notice, section 34 clause 1. So, the questions given the scenario between the Ali, Chong and Ramesh. So, without further ado, let's get started. On 5th July 2017, Ramesh, Ali and Chong successfully registered their partnerships business under the name of Young Success Tradings, which run the business of printing and advertising. The partners agree that the partnership business will end after the expires of 5 years after the registration of the partnership business.
In August 2022, Ali felt that he no longer had an interest in carrying the business as a partner as he wanted to gain more profit for himself. Later, in September 2022, he had given a written notice to Ramesh and Chong to end a partnership business with them.
Ramesh and Chong did not agree with Ali's actions and argued that he must first get their consents to dissolve the partnership business. Okay guys, so have you been watching that scene? So, the issue that is whether Ali had the legal authority to literally dissolve the partnership business of Young Success Tradings without the consent of Ramesh and Chong. Okay guys, so let's look at the cases that related into the scenario at the above. So the cases that related is Sukhjinderjit Singh Smarker against to Arumugan Devaraja. The court held stated that as in the circumstance, the defendant has failed to prove that there was an implied agreement between the plaintiff and the defendants that a partnership could not be dissolved by notice by plaintiff. The partnership was effectively dissolved. Other related cases are the Law Pui Heng against to Tam Kok Chung and ORS.
On to the application. Since Ali felt that he had no longer interested in carrying their business as a partner as he wanted to gain more profit than himself. So the partnership still has a fixed term in expiry in 5 years after the registration of the partnership business. Given that the business was registered on 5th July 2017, the partnership term would naturally expire in 5th July 2022. However, Ali sent a written notice to Ramesh and Chong stating that he wanted to end the partnership on 1st October 2022 and that there would be no more partnership between them. However, the agreement explicitly mentioned that the partnership would end 5 years from the date of registration. Ali unilaterally decision to dissolve the partnership before the expiry of the 5-year term may be in violation of the partnership agreement. Ramesh and Chong can take legal action for Ali because Ali breached the contract for the incident. In a nutshell, Ali had a legal authority to unilaterally dissolve the partnership business of the Young Success Trading without a consent of Ramesh and Chong. Partnership agreements are legally binding and all partners are expected to adhere to the terms and conditions specific in the agreement unless there is a mutual consent to modify or dissolve the partnership.
Next, we have duty to account for any benefit derived from any transaction concerning the partnership. Let's see the scenario between Tom, Alex and John in Smart IT Solution Firm.
Tom, Alex and John are partners in a software consultancy firm called Smart IT Solution, which was established in June 2016. Since 2019, Alex has been secretly taking clients from the firm and doing freelance work for them on the side, without the knowledge of the other partners or sharing the revenue with partnership firm. Tom and John began to suspect that something was not right within the firm.
Mr. Smith, their former partnership client, was requesting to build an app with Alex through Alex's email account. Suddenly, Alex forgot to log out of his email.
Surprisingly, Tom and John were furious. What Alex do? Suddenly, Tom and John know what Alex and Mr. Smith doing. Tom and John decided to sue Alex for making a secret profit out of the partnership property. Alex argued that he never took the partnership's money and that the profit came from his freelance work.
Okay, based on the scene that you have watched, the issue is whether Tom and John can take legal action to Alex because of he made the secret profit without concern of the partners. In the law, a partner has a duty of utmost good faith to his partner, which is duty to account for any benefit derived from any transaction concerning the partnership. Section 31 Partnership Act provides every partner must account to the firm for any benefit derived by him without the consent of the partners from any transaction concerning the partnership or from any use by him of the partnership property, name or business connection. He cannot keep the profit for himself but must account to the firm and therefore entitled to be shared by all the partners. We can see in the case Patirana against Arya Patirana RW, Patirana and A Patirana were partners in a business of selling Caltex. On 10 September 1948, A Patirana gave 3 months notice of dissolution of the partnership. Then on 1 October 1948, RW Patirana changed the name of business from RW Patirana and A Patirana to RW Patirana. Before the notice of the 3 months expired, RW Patirana continued to carry the business on name and keep the profit himself. A Patirana wanted to take legal action to RW Patirana. Court held by privy counsel, A Patirana was entitled to have share in the profit. This was because the profit were derived from the use of the partnership premises, which was without his consent.
Now let's move on to the end application. Alex have made a secret project with client Mr. Smith to do application without the consent of a partner. Tom and John have authority to know who and what project Alex with Mr. Smith because there is a partnership. Even though Alex argued that he got money from freelance, he should talk early about the project to the partnership to avoid misunderstanding among the partners. Besides that, Alex have kept the profit for himself, not to the account firm. That was wrong action in a partnership. In Section 31, Mr. Smith, a client to the business to Section 31, provide that every partner must have account to the firm for any benefit derived by him, without the consent of the other partners from any transaction concerning the partnership or from any use of business connection. In this case, Ali had used the partnership business connection without the consent of the other partners. Alright, based on that situation given, Tom and John can take legal action to Alex. This was because the profit were derived from the use of the partnership business connection which was without partner consent. Tom and John can claim the share in the profits.
That's all from us. Thank you.
谢谢。
Andrew.
Terima kasih.